Opa, já estamos ao vivo aqui em mais uma edição do nosso AACE Connection. Eu estou aqui no escuro, é porque eu estou num táxi, andando pelas ruas de Curitiba, mas quem vai conduzir vocês nesse nosso webinar de hoje é o nosso diretor internacional, Felipe Gutierrez. E it's an honor for me to be here with two colleagues who I met several years ago at AACE in annual meetings in the United States. John Ciccarelli, who was my president when I was director of Region 10 in 2000, I think it was 16, and Steve Warhoe, both former presidents of AACE and international authorities in cost engineering. As my camera is flickering here, I will turn off the camera, and Felipe, you will be our host, and please introduce the two special guests that we have in our last AACE Connection of 2022, and it's double, okay? It's a double webinar. E muito obrigado a vocês todos e espero que vocês tenham uma AACE Connection muito proveitoso no dia de hoje. Um abraço.
Obrigado, Aldo. Let me just make sure. Yeah. You guys can hear me, right?
Yep.
Yeah.
Awesome. Okay. Well, so thank you, Aldo. Thank you very much, John and Steve, for being here today with us at another Connection program with the ACE Brazil section. For the audience listening to us in YouTube, we're going to be talking today with, as Aldo introduced, with John Ciccarelli and with Steve Warhoe about subjects that are of interest to the cost engineering community. Lots of experience here to be shared. If you guys have any questions or comments, feel free to go ahead and share those through the YouTube chat, and we'll happily share those questions with John and Steve. So the way we are programmed to do it today, we have the first hour with John Ciccarelli. He's going to be presenting the results of an article, of a document he has issued recently, named a primer for claims and disputes, Claims 101, and it was issued through the ACE. We'll be able to give us more details on that. And then in the following hour, Steve will be discussing the recommended practice 120R21 that goes by the title Demonstrating Entitlement for Contract Change Orders for Claims as Applied in Engineering, Procurement, and Construction. With no further ado, I'll let you, John, take over now. Feel free to share your screen, introduce yourself if you want to give more details. And then this is just a quick remembering or reminder, of how this program is supposed to go. This is supposed to be very flexible, very informal as well. So if you guys want, if John wants to also ask for opinions of Steve, or make questions or comments, and Steve want to make comments as well, or the other way around when Steve is presenting, by all means. The idea is for us to learn and share experiences and knowledge, and more than anything else, have fun. So it's not supposed to be a very, very formal environment. So with that, John, go on. The floor is yours.
Great. Thanks, Felipe and Aldo, for putting this together. As Felipe said, this is Claims 101, a primer for claims and disputes, and I'll go over kind of why we did this in the presentation. So a little bit about myself. Again, I'm John Ciccarelli. I'm a director in the construction advisory practice at JS Held. For a period of time, Felipe and I worked together. We were colleagues on a project, so that's how we met. I'm a civil engineer by education. I also have a master of business administration, several licenses, including professional engineer and through AACE certified cost professional and a planning and scheduling professional. And as Aldo and Felipe described, I'm past president of AACE, and I'm actually on the technical board now, and working with Steve on the tech board. And actually Felipe got credit for some work he did on an accounting tech recommended practice that was recently approved for publication. So you'll see his name on an RP, which is nice. I'm also on the AACE Certification Institute Board of Directors now. It's a smaller role, but it's important. Certifications are. So I'm doing that now. So continuing to help AACE. And I've been in the industry for about 35 years and qualified to provide expert testimony on delay and some damages before in various venues. Something you don't know about me. Last Tuesday, I won my first election for public office. I'm going to be on the township committee in my hometown, so ran for it, campaigned, shook people's hands. Now I'm a public official. Thank you. So I don't know if that's a blessing or not, but last at the annual meeting, what you didn't know about me was that I was a candidate. Now it's official. Oh, there I am. Yep. So
impressive. Oh,
something else on my plate, right? For today, well, I'm going to go through an introduction again to kind of give the context of why I prepared this presentation. We'll talk about the dispute process, the various components of a claim, and briefly touch on preparing a claim. This dovetails into Steve's presentation. So, Steve, if I'm going too far and we're going to cover something later, give me a little sign and I'll cut it short. But Steve's presentation will elaborate on it, and there's actually a tie-in to my paper at a spot. So these two presentations go well together.
Okay.
So, as Felipe said, on August 24th, I published an article at the behest of the tech board, called it Claims 101. So it's a primer for claims and disputes, Claims 101, very basic stuff. But the reason I did it was that, the CDR committee is a group of professionals. We analyze, manage disputes, dispute resolution topics, and really focus on schedule delay, schedule, cost, productivity, issues that are very near and dear to our heart. But what we noticed was that there are, we think it would be useful for other practitioners in these other subject matters to be familiar with disputes, because the work that they do, the work that AACE colleagues do and their knowledge, typically end up being analyzed by us. So it would be better if they knew where a bad decision or taking a shortcut may end up in a claim or a dispute. And it kind of serves as it was to serve as an introduction to people who are in contract management. And they say, yeah, we get in claims all the time, or we don't, we manage them. What do I do if I do come across one? But cost estimating ends up in, if you're doing a total cost claim, you have to look at the estimate, right? So we need to be familiar with cost estimating. Risk management, decisions that are made on a job, earned value is used, and there's SPIs and CPIs, and how does that affect what's on a critical path or productivity factors. Planning and scheduling, obviously, if you're going to do delay. Cost control, project and cost control, how was it executed, and value management. Again, decisions that are made that affect the cost and schedule on a project, they're all in silos, but when we do a dispute or a change, we always go to this information. So I always thought that all of this work, being like a CCP, you really cover all of these topics, and forensically you get into the data. So it'd be good for estimators to know, where this could be used and how they should document their assumptions and how they put together their estimates or schedules. It all comes around eventually should something go sideways in a dispute or a claim. So that's kind of the context. And I know this is part of Steve's as well. So he may repeat this to you, but I guess if you hear it 2 or 3 times, you'll take it to heart. But a dispute is defined, and these are AACE definitions, as a disagreement between parties, like an owner or a contractor, and a contractor, is to a question or fact or contract interpretation which cannot be resolved through negotiations to the mutual satisfaction of those parties. So something is not agreed to. They're disputed whether a change order is a change order or not, and they can't resolve it. And whereas a claim is a more formal document. It's a written assertion of rights for damages sustained under the terms of the contract. It could include, the damages claim could include money, time, or other compensation or relief from contract requirements. So for example, they want relief from liquidated damages because of a delay. So that are being assessed by an owner. So all of that is in a claim. Again, they're a little more formal. And I think that's, I guess in general, a dispute is a general disagreement, while the claim becomes a more formal process. So there is a distinction between the two. Typically, they're between an owner and a contractor, where the owner expects the contractor the owner issues a design, the contract, and expects the contractor to construct the project as described in the contracts. A designer is responsible for preparing contract documents. The contractor determines the means and methods, and assumes that the documents are complete and they can build the job. And typically there's a contract to say if there's going to be a change or there's a deviation, we get paid for it. So typically that's how it's between an owner and a contractor. But there's all kinds of other stakeholders. There's designers and their sub-consultants. There's typically a construction manager might be involved, subcontractors, insurers could have, they could be a client. There's other consultants, owner, permitting authorities, and governments, and then funding partners, people who are providing the banks, the letter of credit parties. So there's a lot of stakeholders who may have an interest in a disputed matter or a claim. But what's typically, you have all of these parties, the relationship then is dictated by the project delivery method. Also, is it design, bid, build? Is it an EPC contract? Is it a design build contract where you may have a claim between the designer? That's where you might have a claim between the firm that designed the job and the firm that bid it, and the lead party, let's say. Construction manager at risk. There's other alternative delivery methods. Each one of those, allocates risk in a different way, and how that risk is allocated could determine how a claim emerges. But that also impacts the form of contract. Is it a fixed price or lump sum? Some parties, owners will think, well, I have a fixed price, I have a lump sum contract, it's turnkey, I don't have to do anything. And that's not true. There's still responsibilities dictated by the contract, but that's one form. There's cost plus fee, which may also have a guaranteed maximum price. The contracts have clauses for savings, clauses for how contingency is used, if the price is going to be over, and procurement. So there's a lot of nuances in every contract that you need to be understood. And I'll probably say this a couple of times, but the assumption is that the project participants, if you're a contractor, if you're an owner, have read and understand what's in the contract. Now, you don't have to read the entire contract, but there are certain clauses that are key. And, an entire contract can consist of, it could be voluminous, right? A lot of them are, if you wrap every document in, include, you have a standard agreement, maybe some addenda that came out, pre-bid or post-bid. There are general, special conditions, supplemental conditions that are issued. There's technical specs, plans and drawings. Then the proposal and the bid may be incorporated into the contract. And then there's additional supplementary types of documents that may be applicable to the contract. But you need to know what's in the contract. As I said, technical specs may or may not be that important when you're managing a contract or preparing. They are important when you're establishing entitlement. We'll talk a little bit about that later, but some of the key, typically when we're doing a claim, the first thing I go to are the general conditions, and specific requirements, like understanding changes and claims. What are the clauses for the change process, and associated time extensions. When do you have to initiate the change order or a claim? What type of notice has to be given, which is actually bullet point 3. What type of documents need to be maintained. So understand what you have to do if and when a change occurs, which will lead to a claim. Could lead to a claim. What are the time and schedule requirements? Understand what those are in the contract. Are there milestones? Is there a liquidated damages claim? Are there special conditions, technical elements for the schedule? Do you have to use a CPM? Are you going to use March charts for a pipeline? What's the level of detail that the owner wants to see or that you should develop? How many relationships? How is float treated? Activity coding that's required. We've seen that dictated or spelled out by owners. And then what type of reporting does the owner want to see on a monthly basis? Do they want to see modifications to the schedule? If they are, you have to be prepared to provide that information. So and then if there's delay, what are the recovery schedule requirements? If this project falls 2 weeks behind the contract, the owner might want to see a recovery schedule. So what do you have to live up to when it comes to the time and schedule requirements of the job? Notice, follow the contract notification requirements, and whatever follow-up actions need to be prepared, even if it's a rough order of magnitude estimate. Follow through on that. If you miss a notification deadline, your claim could be denied. I've had that experience where notice wasn't given, and summary judgment, the judge decided to throw out a claim because notice wasn't provided. So it was unfortunate for the contractor, but and they knew it all along, but they proceeded and gambled and lost. And then force majeure events, understand what's in that clause. So these are some of the key contract clauses. That could influence a disputed issue or a claim. So these are the key ones that we usually go to. There's probably some more. Maybe Steve will mention a couple, but so those are key. So understanding the contract and what you're supposed to do from a management and project controls point of view is very important. So what causes changes or disputed matters and could result in a claim? Here's a list. I should have highlighted a couple that we most frequently see, but scope, number of scope, and change orders as a result of maybe an undefined scope is probably the lead one, but differing site conditions is always a good one. Design errors and omissions which lead, could is the same as incomplete, or not the same, but is related to incomplete or late design issues or ambiguous documents. Cumulative changes, that's something that Steve is working on now, an RP for that. Very interesting. Unusually severe weather. What is unusually severe weather as opposed to severe weather that's expected? So delayed in owner procurement, if there's work suspension, acceleration, constructive or otherwise. Acceleration could be a presentation unto itself, but is there interference by trades? Shortage of skilled labor is something that's been emerging these days. And just if you're an owner, you're also, or a contractor, you have to know or understand if the contractor's own performance may have impacted the job as well. And that comes in if there's potential concurrent issues on schedule delay or cost overruns and productivity. Are there quality issues? Is there workmanship issues that require rework of work? So all of these things, a combination of these, a result of one or more of these, might result in a claim or a dispute or come up, and could result in the need for, if one of these events happens or you notice it, you should provide notice. And again, follow the contract to make sure you establish entitlement or at least the ability to put in a claim. And we'll talk about the process next. But again, one or more of these matters, and there's probably more, or a combination of these can happen. So that's not the entire universe, but it's general enough to cover all kinds of issues. And so we can get into a typical process for a claim. And I don't know if now's the time to see if anybody has a comment or a question, just because I'm getting tired of talking. But anybody have any observations or contributions at this point?
Yeah, I was going to say, John, it might be, it might be interesting to hear what Steve has to share as well, like if he can now have some thoughts. And I did see some questions coming through the questions and answers, so I'll let you know as well about that. I just wanted to make like a very brief comment on those causes for a claim as you are showing them through. We see more and more not necessarily new causes, but they're new as well, but some of them are just changing a lot, such as climate related risks, right? So now we used to have those those rains or those floodings and stuff like that would happen every 500 years, right? Like 100 years, and now they're happening much more often. So those are things that might be impacting projects more and more, and how to deal with it is getting more and more interesting because it's impacting everybody everywhere, and we just don't know how, because the old models are not good enough anymore to determine if they were foreseeable or not, and the impact of the extent of the impact that they have in projects can be catastrophic many times. I think it's very interesting how it develops. Sorry, go on.
I'm sorry. The only thing I'd like to add, I mean, John's doing a great job, obviously, is that in my research, design errors and omissions is by far the most common cause of disputes and claims between contractors and owners and designers. And I guess my only advice is, for contractors is, when you get a design, especially for design bid build type of projects, study that design before you bid it and understand as much as you can any nuances that you might find, and ask many questions because down the road it could turn out to be an error and omission dispute, because that's, like I said, it's the most common reason for those types of disputes in general.
Yeah, I can see where that's tied to something like scope or a change order, and then who's fighting over it, right?
Exactly.
Because
Exactly.
if you're a contractor, depending on the form of contract, you might not have privy to the designer. So you've got to go through the owner. So the owner's going to push back.
Right.
But on one side, on the other side, the owner is saying, well, how do I sue my designer? So, right. That frequently happens.
But the contractor has to protect themselves. I mean, the ambiguous documents item there is that's excellent. I mean, to put that out there, because there's so many contractors are, sometimes they don't have their own design people. So they don't understand engineering concepts and why X is Y or Y is Y. So they need to ask those questions. Hire an engineer if you don't have one, if there's something you don't understand.
Yeah. Yeah. It's definitely again, the privy to the contract. You can't, typically you can't sue the designer if you don't have the direct agreement with them.
But you can review the drawings. I mean, drawings, specs.
Yep. Yeah.
But we see a lot of clouds. You better start asking questions.
A lot of clouds, a lot of revisions. Yeah.
That's right.
The other part of that is, and I don't have this anywhere in here, but how often do you have a contract where the decision maker, at least in the contract, is the engineer or the designer? So you're submitting a claim that somebody missed this in the design, and the engineer is going to say, well, no, it was in there, you should have assumed it, right? They're not going to admit that they were wrong.
Right.
So that one always gets me. It's the fox watching the hen house, to borrow a euphemism, but it always amuses me. I mean, it shouldn't amuse me, but it's just, what did you expect the engineer to decide? Right. So you're right. If you're a contractor, as Steve suggested, it might help, it would pay to have somebody look at the design from that perspective. Just, do you see changes? Do you think it's complete? I mean, that's the Spearman doctrine. I think, is that uniquely American, Steve? That the design.
Yeah, I mean, that's based on U.S. law.
Right? But it means that the contractor, can build the job as designed, and that there's, the documents are complete. I mean, that's really there's case law in the United States about that. So
I mean, it goes into, there's a fine line between how detailed is detailed for a designer to go into, and then how ambiguous is ambiguous for a contractor. I mean, there's a big gray area there for the design.
Right.
Yeah, I was going to say this. In my experience, this is not a privilege of the U.S. I mean, that's a discussion that you'll find everywhere.
Yeah, it makes sense.
It's often the case that just because there's so many, like especially in public procurement, there's so many questions and answers. Sometimes a small answer can be hidden in the middle of so many of those, and if you don't review those, like Steve was saying, John was saying,
it's got to be
everywhere. Might do something different, and then you are taking the risk as a contractor, right? Then have to deal with it.
Right. Okay. So, Felipe, I'll move on unless you've got a question from the audience.
Yeah, we do have a question. It's not necessarily, but it's broad, the question. So
maybe we'll save it. You want to save it for later?
I'll tell you the question, then you decide if you want to answer it now or later, depending on what you have in the presentation. Okay, it's very specific for IPD delivery. So it's asking, is it possible to have a claim amongst parts? I'm guessing it's different between the different parts or the involved parts in the project when they're using the IPG product delivery method.
So IPG is integrated.
IPD as an integrated project delivery.
Yeah. I, as a general statement, I'll say you can have a disagreement about anything, but if there's an integrated project delivery, there's an agreement of some sort that that the parties have, and whether or not they live up to their different requirements. You know, if one party starts to fail on their end, there's going to be an internal lawsuit, right? Or there's going to be disputes among joint venture partners or an integrated project delivery. It's still, you know, partnering or these or alternative project delivery methods require that people work together, and it doesn't always work out. So you still have to, you know, you go in with a positive outlook. We're going to do this, but the minute somebody starts losing money, you know, you got to protect yourselves. And so I don't know if Steve has an additional input on that, but you know, it's all well-meaning at the front, but you know, you trust people, but you verify that they're doing what they need to do.
I have nothing to add. I agree with you, John, on that.
I was going to make a quick comment, if I may, because I mean, there is just the understanding behind the word claim, right? So not necessarily a dispute, but if you're talking about, you know, a change, things happen, right? Even in a like, you know, you can get as close as you want from a contract delivery model and have the teams, you know, very integrated and working, you know, sharing information and being collaborative and all that. But then, you know, you can't preview everything. So there will be circumstances where a claim is required, and you know,
right. It's a dispute. You're disputing what's going on the job, and it may end up in court at some point. And we'll talk. There is a flow chart in one of the upcoming slides where maybe we can expand on that a little bit. So very basic process. We talked a little bit about this already. The contractor might request a change, or there's a dispute for something that they think is extra, not in the contract. The owner rejects the claim. They reject the request, I should say. They reject it on principle, let's say. They say, no, we don't think you're entitled to extra money or time for this particular issue. So then the contractor files a claim, and that, you know, a more formal claim, and then you proceed through a dispute resolution method. And the methods, we'll get into these a little bit, but two things. One, there's a dotted line across here where in the methods on the top, it's quote unquote self-decided, where the parties still have a say in the decision. You can negotiate it. When it gets below that line, arbitration and litigation, someone else is deciding your fate, and anything can happen, right? So you have avoidance, negotiation, mediation, dispute review boards. Above the line, let's say, where you have some decision you have participation in the decision. When it gets to arbitration litigation, not so much. And so that's we'll go over these briefly. So where, you know, so the self-decided methods, avoidance, like somebody, it's like, well, you just try and avoid the dispute. You just put it to the side, and, you know, just hopefully it resolves itself. And that typically never works, never happens. They just become bigger problems, don't self-resolve. Negotiation, you know, how are the parties involved will negotiate it, and casual could be done online, you know, depending on the size of the issue, the order of magnitude of it, conversations, emails, texts among the project personnel. And even the more formal meetings, presentations among the parties, where parties are talking, right? You're going to resolve who's responsible, how much, what are we going to do about negotiating this particular issue. And the size of the issue matters, because you don't know who has signing authority in the contract, or you need to understand who has authority to, you know, somebody might be able to sign a change order up to $10,000. Well, we've got an issue here that's, you know, $500,000. So who's that going to go to? So you need to understand that. And You may still be able to negotiate it, but it's got to be the right level. Mediation, where this is an alternative dispute resolution method where the parties will bring in a neutral person, somebody who's uninvolved on the project, to facilitate the parties in reaching an agreement. Mediator, what needs to be understood is mediators typically don't render an opinion. They lead the questions and decisions made by the parties. They go back and forth. Parties are in separate rooms typically, or they might make a joint presentation and then go to their own rooms. Mediator goes back and forth, communicates strengths and weaknesses, and, well, why don't you think about this and that, and try to get the parties to mutually agree, and that they don't make the decision. And so that's mediation. Should be, and that's something we frequently have to communicate to clients, is the mediator doesn't make the decision. You do, right? They might give you some opinions, but you make the decision. DRBs, dispute review boards, that's typically a process that's in the contract. There might be 3. I think I've seen one where there was 1, but 3 neutral members. They make they decide on disputes. There's been several presentations on DRB boards at AACE conferences as well. There's usually site visits monthly. They conduct hearings. They want to know that they're participating in the job a little bit more than an arbitrator. So it's not, every issue is not brand new to them, but they at least it's defined in the contract, and there may or may not be experts involved, but it's and depending on the size of the matter. So they may request formal analysis be done, but it's defined. So DRBs, they help resolve it before it gets to a dispute, before it gets to a claim, or before it gets to arbitration or litigation. Arbitration is a little, let's say, less formal than litigation, where it's going to an impartial panel. Could be one person, but again, typically 3 for a final and binding decision known as an award, binding or non-binding, but they're made in writing, generally binding on the case, and there's typically document production and a formal process. There's organizations that ICC arbitration. There are organizations that have processes that you need to follow. So it's not as formal as litigation, but it gets there. There was some criticism that arbitration is becoming just as cumbersome as litigation, because document exchange in electronic form is still an enormous task. But the arbitration tries to control the amount of information a little bit. Litigation, again, that's brought before a more formal government agency. It's adjudicated in a court. There's a judge. There's a decision made by a judge or a jury. That's typically more exposed to the appeals process and can be a lot more. It could be a lot lengthier. So, those are the 2 options that generally claim. It's once you've gotten into this, you're going to be spending some money on lawyers and experts. It's if you decide if you end up in this route, you have to make some decisions. And typically, I'll touch on this briefly in a little while, but typically the analysis and everything and that you're doing for the more formal processes, when you're going to a dispute review board or a mediation, and you're submitting a claim or a change order for a disputed matter, you should be doing analyses that support it. And whatever analyses you do up here should flow through down to litigation. It should be the same information. So, excuse me. That's just something that when a disputed matter arises, think about the types of analyses that are going to be done. So most contracts have a process for that. Oh, and what I was going to say was, typically, if you're proceeding into one of these arbitration or litigation, here in the States, in North America, if you're in a court process, they will still ask you to mediate. So it's not that these things happen inside, without happen in silos. They can happen at the same time. So all this information, you're using the same information to decide how you're going to resolve a dispute. So, but the contracts typically have that information. It typically says what's required to be submitted. And, if you fail to follow that process, you might lose that opportunity for recovery. So that's kind of the background for claims. I'll get into I got about 15 minutes left. We're going to get close here. And Steve, like I said, if you're going to cover something, tell me.
Yeah, John, this whole slide is what I'm going to cover.
Okay, so I will go rapid. I'll go through it pretty fast. So,
all right.
The components of a claim: entitlement, causation and responsibility, and then quantifying damages. So those are the key components to that. So entitlement, review the contract, understand the dispute resolution project. So there's two elements here, and Steve may or may not cover like a legal perspective. What are the laws and regulations that are applicable? But technically understand if it was a change order. Was it really out of scope? And then what's required? You have to do a time impact analysis. So understanding those elements. Causation, do some type of cause and effect analysis. So you got to establish causal linkage between the events and what happened. And we can talk about schedule delay analysis, labor resource productivity analysis, and then there's other technical analyses that get done. So these issues could be what most of us probably know, that these could be presentations unto themselves, a full hour, a full day on schedule delay. So there's a lot of RPs, there's a lot of information on how to do a schedule impact analysis, whether it's a TIA where you're inputting fragnets and project forecasting delay, or which is typically when you're on the project, that's what you're submitting. After the fact, forensically, if the job is over or after an event has occurred and you still haven't resolved it, it may take on a slightly different flavor. It will be more of a forensic analysis after the fact. But when you're submitting a change order, you may be forecasting as well. But all the things you consider in an analysis, baseline schedules, rebaseline. Again, you do a whole presentation on schedule delay, but needs to be considered when you're, it's a key element of a claim in a dispute. From the 101 perspective, from the the schedules are very important. There's different types of delay. I don't know, Steve, you get into this, but whether it's excusable or not excusable, understand what's in the contract. There's concurrent delay. That's an issue that comes up in schedule analyses. So understand if you're a contractor submitting a claim, understand if you're at risk of having caused delay yourself. And when you put that claim in, what could the owner possibly say? That vice versa. If you get hit with like liquidated damages, you could say, "Hey, owner, you changed all these things." So if you're an owner and you want to go after liquidated damages, you better prove it, and you better be able to prove that it was a contractor delay. So this goes both ways. So that's schedule delay. Related, loss of productivity. Steve's pretty versed in this, but understand that that there could be a loss of productivity. That's an element of your damages and your claims: extra time, extra labor hours. How do you measure loss of productivity? Do you have the data for it? Can you present curves? There's different methods. Again, if you're forecasting out versus looking back to see what actually happened, depending on that perspective. But there's different ways of There's project-specific studies like a measured mile analysis. Again, these can take this presentation on that alone could be a day or an hour for measured mile, only understanding it. Earned value can be used. There's direct observation of a specific project to study the time that labor, what your labor is doing. And then you get a little more generic specific studies on like MCAA or CII and any other forward pricing guides to say, we're going to experience congestion. That's a 15% hit, we think. And so here's the number. And then there's cost-based methods, total cost or unit cost. The total cost, again, that's mostly after the fact, but that's, if you're going to get into a claim, understand that there are various methods of quantifying damages. Labor is a big part of it, and how you track your costs is very important, and the records you keep on labor. So it's very important. If you don't have it, you're paying an expert, and it's a risky. It's risky if you don't have the proper documentation. I always put this in here. There's other analyses that help prove entitlement, like looking at change orders. You have a change order log where we can look at the amount of a change order, the timing, the cause, what are they from, how long did it take to turn the change orders around. All that impacts how a project is executed and can cause delay and disruption. Same with RFIs, same with shop drawings. How long was the turnaround on shop drawings? And you're pointing the finger at something that the owner may have had control of. Submittals, are there design revisions? Again, keeping track of engineering issues are important to demonstrating causation. Quality, contractor, you need to understand if there are NCRs or there non-conformance reports or rework. That data can be analyzed. Is there rework because of one of your subcontractors? Understanding those other issues complements the big three, which schedule, loss of productivity, and damages. These help demonstrate, as well as any charts, graphics, illustrations. All of that helps present the story for a claim. And again, it's what people are doing on project controls to keep that data important. So, ultimately, quantifying the damages is where the rubber hits the road, right? That the dollars. Correlate everything you've done, delay, correlate that to the various methods to quantify the costs. Discrete is the most favored and most accurate. That's what you like to see is specific estimates, measured mile, earned value. So try and get down to a project specific approach. So if you're controlling a project, try and have a WBS, have a set aside for account for change order costs or extra costs. What I could have said on loss of productivity is it's really hard to track specific loss of productivity. So you have to do analysis to extract it from your costs. So I think that's that's why all of this is important to quantifying the damages and trying to take the most discrete approach as possible. Total cost methods or modified, those are usually the most subject to the most scrutiny and criticism. So you have to be careful when you're quantifying those additional costs. Costs can be unpaid change orders. Steve will talk about that. There's delay costs for time related. Loss of productivity is included in the cost. Acceleration costs, is there a premium? So keep these different types of costs in mind when putting in a change order, because if you miss something, you might not be able to go back and claim it, or you might not get a second chance. When you put at the end of the day, there could be unpaid contract balance. unpaid change orders, all of the direct costs. And this is just things to consider. If you're on a project and you're putting together, you have a disputed matter and they say, well, what's the impact here? These are all the types of costs that you may incur. Labor, material, equipment subs, indirect costs for time and general conditions, overhead. There might be a corporate costs to that. There's the Eichle formula or other overhead allocations, insurance, interest, bond, profit could be included. So some of that is dictated by the contract as well. Understand what's in the contract and what you can claim and what can go into a change order. And make sure you explore and understand all of the ways that a dispute or an event could impact you. We say there's really three things: schedule, productivity, and damages. Documentation underlies all of that in my mind. That's the fourth element, fourth component that underlies, it's the bedrock of all of that. So we've talked about all kinds of data and documents to prove it. So documentation times 3, Steve will probably touch on that. So, at the end, when you're going to, I put conclusion, but I think it's actually, when you prepare a claim, if you have a disputed matter that hasn't been resolved and you're going to prepare a claim, prepare a timeline, schedule it like a project. What do you need to develop and file the claim? Understand the deadlines. Some of them are complicated, some of them are not. Adhere to the claim requirements and those deadlines for the various submittals. Hire counsel. If you have a lawyer who's a general counsel as an owner, or general counsel for you internally as a contractor, you might need to hire somebody who specializes in construction disputes in the jurisdiction in which the project was built. You have to consider it. You may need to hire a claims consultant. That's not a shout out. I'm not advertising, but you may need to if you're a contractor or an owner. If you hire counsel, they may tell you to hire a claims consultant, but consider the legal avenue and count. I always say, who's your lawyer, right? That's always question number 2, maybe. Draft the claim, articulate the claim, confirm entitlement, do your forensic analyses, include documents and graphics, specific references to project documents, consider all the support documentation, which now includes electronically stored information. So consider that, if you enter into litigation, that's all going to be requested. Everything's going to be requested. And with that includes emails and text messages, right? Felipe, we were on a job where they got everybody's iPhones and downloaded all the emails and stuff and hung a couple people on what they wrote in texts. And understand the audience, who you're writing this for, and what's the overall venue. Is it going to be in a mediation, or understand your audience when putting a claim together. So that's claims 101. A lot of different things to consider, and the purpose again is just to kind of open people's eyes to the world of claims. We did this one time for the American Society of Civil Engineers. They do a lot of design work, it's all design. It's very technical. And we came in and said, well, you design rebar cages, but here's what you should consider, when you're doing your design, or, don't think that just because you're here that you're not liable at some point for a potential claim. It's just kind of to open people's eyes. And I always thought, if you looked at the body of knowledge of AACE, a lot of these things get tied into what everybody does. And so, somebody who does estimating may or may not be interested in claims, or maybe they are if they see this and say, hey, I remember that happening, or I remember getting called to the mat by my boss one time because we didn't have contingency in our estimate. And we recently had a case in New York where it was a design build project, but the ultimate contractor bid the job with zero. They bid it as if it was 100% design, and it's admitted to it. And we used AACE recommended practices on schedule or estimating level of accuracy, just to simply say, you said multiple times that this design wasn't done, but but you bid it as 100%. And if you look at AACE's recommended practice for what this level of project development was, you should have had at least 20%, plus or minus 20%, but it shouldn't have been zero. And if it is zero, you took the risk. So that's the way that the panel decided, which is good for me. But it just shows that there's other elements in AACE that tie into everything that we do on the dispute side. So that's it. A minute over, and I think I can pass the buck to Steve, unless there's one or two.
Don't pass the buck, pass the baton.
Pass the baton. I'm sorry, that was my old government job days. They had a buck sheet. Just pass the buck. Pass the baton. Thank you.
Thanks, John. Thank you very much. Very, very interesting. If Steve don't mind, I'll just go through two questions we received very quickly. And I'm sorry, one of the questions came a little late, and they're like in the middle of your presentation. They're talking about when you're talking about the continuum of dispute resolution. They're asking, how often do you see DRBs in contracts in the US? And is there a minimum value that makes it feasible? I'll just make a quick comment before you answer, is that, at least as far as I can tell, in the US, you'll see more often than not DRBs, as in dispute review boards, meaning that they issue a recommendation for implementation by the parties. And in Latin America, you'll see them being the dispute boards being more effective when they are DABs, meaning adjudication boards, dispute adjudication boards. So they're there, very similar function, but in the end of the day, they actually issue more than a recommendation. It's an adjudication. But they do issue a decision that is binding, temporarily at least, that could be reversed through, normally arbitration. So what that does is that, if the contractor needs the money to continue alive as things are happening, that happens. So the money changes hands, and then it can be, again, if the contractor or the owner is not happy, it can be reversed later on through arbitration.
Interesting. Where do you see the DABs?
In Latin America, you see them more and more. There's a very interesting and successful experience, at least as a start, in Peru. There's about, I want to say, like 40 dispute boards already implemented in the last few years, just a few years. And there's a lot happening there. So they're trying two ways, what they call juntas, what they call it JRDs, which are juntas de resolución de disputas, which are more local, following local laws, etc. And in the context of many projects that are being financed by the UK through and developed as well through a government-to-government contract, there are many projects being developed, and they're even using NEC contracts. So they're doing that through those contracts that are very UK-centric, and but they're implementing GABs, and it's been a very interesting experience. It's kind of new, so of course it's a process. There's a learning process, a learning curve there, but they're using that more and more, and it's been an interesting journey for the last, I want to say, 5 years.
That's interesting.
Yeah.
So I've only come across a couple of DRBs, and they've each one was a state Department of Transportation job, and the other was a federal contract. So government jobs, I think, might be pushing DRBs. So those are there's only not a lot of them. I haven't come across any DRBs in a while. The DABs I find interesting. I've had a couple of contracts with change order clauses where if they can't agree to an amount, the owner will pay a percentage of the change order to be finalized at a later time for the same purpose, so that there's funding involved and you figure it out later. So at least the contractor's not financing the entire change order. Maybe it's 50% or 75% of an estimate. So that I've seen that. I don't see that often anymore either, though, just to kind of keep the funds flowing. But so I haven't seen too many DRBs, but maybe it's just my clients. I don't know about Steve.
Well, I'll just say I've worked in and been part of DRBs. I mean, contributed to, and my experience is for the small dollar things, the low risk things, DRBs are great. But when they become high dollar, DRBs, one party or the other after the award is going to, because it's non-binding, they're going to reject it and want to go next step. An example of that was I worked on the Panama Canal expansion. And it's exactly how it went. There were some big ones right early in the beginning, and they just festered, continued on till, never were resolved. They tried negotiating, even the DRB came in. It had to be arbitrated at the end. But the small stuff, yeah, no problem. They took care of it. And that's been my experience as well in other places.
Yeah, and just a quick final comment from that perspective as well. I've been more and more involved with the DRBF, the Dispute Resolution Foundation Board here in the US and in Latin America. And I tend to see that a lot of departments of transportation use the DRBs here in the US, and it seems successful.
Well, and I've worked on some big projects here. I live in Washington State, and I've worked on a couple of $4 billion program. I was the program manager on one of them, in fact. And DRBs, like you said, Philippe. But again, if one of the parties still is not happy at the end, they're going to go to the next step. They're going to reject it. And that's usually what happens.
Fair enough.
Because DRBs tend to, at least the theory is, they tend to split the baby, as we call it. They cut it in half. They try to make it equal for both sides, where either both parties are not happy or both parties are happy, but usually that's not how it happens.
Yeah, that's not
usually it's like all or none. The contractor wants everything, or the owner wants everything, or most of it. They don't recognize, because, and I'll talk about this shortly, but I mean, emotion gets involved with a lot of this. And that's when I was in Panama. That's exactly what happened. Emotion gripped both sides, and they weren't seeing the reasonableness of or unreasonableness of their positions. And that's usually what happens with DRBs. And when in an arbitration and a trial or a court, they don't care. They don't care about what you feel. They're going to show me the facts.
Exactly.
Yeah, a good settlement is when both sides are unhappy.
Yeah.
Right.
But it's binding. Yeah. Yes. Yeah. I agree.
And just a quick question. Also, perhaps Steve can touch more base on that as well. But the question was if we can claim home office overhead in claims of extension of time.
It depends on what the issue is. You can't do that for everything, obviously. It depends on, if your normal cost structure includes home office overhead, and that home office overhead is reasonable, you're not putting all of your annual home office overhead into one of your 20 projects that you do a year. And I've seen projects like that where they try to cover the home office overhead for the whole the whole office, in one project where they can't, they've got they got many other projects going on simultaneously. So yeah, you can claim for it if you want, and I'll talk about this later about, you got to demonstrate, and John touched on it, your cost, your quantum, you got to demonstrate that it's reasonable, not only supportable, you got the receipts and everything, but you've got to be able to demonstrate it's a reasonable cost.
Right. Yep.
Yeah, agreed. We see a lot of creativity coming through in some of those claims. All right. Well, thank you very much, John. That was really good. Now we're gonna jump into Steve's presentation, which is in a way a continuation of this conversation. I would like to invite John as well to jump in as Steve did, and Steve, do invite John or ask questions, and as you feel fit. And you may.
I hope I do this right.
Floor is yours. Mic is yours.
Do you see my opening screen there? Is that right, or is it my combo screen?
I think it's the combo.
Really?
Put it as presentation.
No, for my presentation, does it say Brazil section at top?
Yeah.
I mean, does it have my next slide to the right, or is it?
It does. It does have the.
Okay, hold on a second. I swapped wrong. How's that?
Yep.
So now do you see the main one?
Yeah, just the presentation.
Perfect. Okay.
Yeah, and in YouTube, there's a little bit of a delay, so I'm guessing it's going to be
okay,
just like that as well at the moment. Go on.
Okay. Well, what I'm going to talk about is a little bit about a recommended practice that AACE just published in April of this year. And it's one that I wrote, and the reason, well, I'll go into it a little bit here in a bit, but what John just spoke about really dovetails into what he just spoke about. And it takes part of what he said and adds some process to how a contractor should look at how they submit a claim or a change order, and their chances of success of getting it approved, how it will increase a lot, or the fact that a dispute, the chances of a dispute will be reduced a lot if you follow these steps. And being in this business for as long as I have in disputes, I find that most disputes, the contractor or the owner have disagreements on any of these steps because there wasn't enough discussed about, provided by the contractor to explain the certain elements. So briefly, I'll talk about myself real quickly. I've been in this business for 36 years. I've testified just like John has on all kinds of different projects. I've testified on projects. Just the part that I testified on was over $1 billion. So I've worked on some very big projects, and I've worked on many smaller projects. I do have a PhD in project and program management, and it has to do with productivity loss and cumulative impact, like John was speaking about before. I was past president of AACE at one time. I'm now an honorary life member. I was very dazzled when I got that. It was totally a surprise. I'm a certified forensic claims consultant, and I'm currently with John on the technical board, and we review all the recommended practices. We vet them, and we publish them for AACE, and the RPs, and at least in my opinion, are really the heart of what AACE is about. It's the intellectual property of AACE that creates what the certifications are about and what the education is about. And so that's, this is, and we're expanding all the time, adding more recommended practices in all areas of what we do. I've also authored another RP. It's about contract change management, and John talked a little bit about that. And I'm going to touch a little bit about it also, because I've also noticed in my experience, contractors who've gotten in trouble, not their own faults necessarily, but the contracts themselves were weak in how the change management process should flow. And there was always, which created confusion between the owner and the contractor on what steps should be taken and when and how. So this RP, the contract change management, offers a way to get to the point of a good solid change order or a claim submittal. And then I also authored the RP that we're about to talk about. So the agenda is, I'm going to talk to some, I have to talk caveats because we're in a litigious society. So I have to make sure. I've had some attorneys review this RP and took exception to some parts. And I've got to make sure that if there's any attorneys watching this, and I don't want to get cross-examined on it, any details here later, is that, you know, and then I'll talk about why we need the RP, the purpose of the RP, and then, like I said, change management process, and then I'll go into the steps of the recommended practice. So the caveats. This is not supposed to be legal advice. I'm speaking to you as a practitioner who's been doing this for 36 years and has run into this time and time again. I've worked in the trailers. I've worked in, construction management offices. I think I've seen it, just a lot of things. And so I'm not one of those people who's been my only job has been claims consultant. I've spent half of my career as a construction manager, or civil engineer, or working in some form of construction besides claims. So same thing with terms like entitlement, change orders, and claims. These are terms that attorneys tend to think that they own them from a legal perspective. They don't, in my mind, because people like us who are practitioners have to use them every day, and we don't have to ask for permission. We have to use them. We don't always have an attorney sitting next to us in the construction trailer. And this RP, as I know, should not replace what's in your contract, but it can be used to help support what's in your contract. Okay, so why do we need this RP? Because demonstrating entitlement, as John was talking about, entitlement means, that you are deserving of whatever, as a contractor, you're deserving of the added cost or schedule delay days in your schedule based on based on what support you provide to the owner that makes you deserve those days. That's entitlement. Demonstrating change order entitlement is often not clearly defined in contracts. As I said, I've read contracts where the whole change order process is written in a paragraph. That's it. And there's no detail. And I've seen some where the change order process might be 5 pages, but still has a lot of gray areas, a lot of subjectivity in it or I won't say it's subjectivity, but gray area, some areas that are questionable on what they mean. And as I note here, because of that, we get a lot of disputed changes. And one thing that I would recommend is that if, as a contractor, you read these, and maybe they do, but read and understand the change order process before you sign the contract. And as John said before, the contractor should read a lot of parts of the contract. And I'm not talking about just the foreman or the head guy. I think the people who are doing your change management process, all the people who are involved in the process of change management should understand the change management process as defined in the contract before, because they're going to be the ones writing the change orders. They're going to be the ones supporting those change orders, and they need to understand what it's going to take. So the purpose, again, of this recommended practice is to provide guidance on the critical elements necessary to demonstrate a technical entitlement, not legal, in support of a change order request or claim. The same process needs to be followed for not only for a change order, but for a claim when developing it. It's just to the extent of how far you have to go sometimes. Okay. So this real briefly, I'm just going to touch on the change management process. And as I already previously noted, the parties should agree to it. And sometimes the contractor doesn't have a choice. They get what's in the draft contract. Usually that's the way it is in government contracts. But that means the contractor really needs to thoroughly understand the terms and what burden they're going to have, what efforts they're going to have in preparing a change order or claim. Remember, a contractor doesn't usually submit in his bid time to prepare change orders and claims. Usually they're thinking, everything's going to go swell. This is a competitive bid. I'm not going to put any extra money or hours in for change management. Sometimes they do, but a lot of times contractors don't think that way. And so when they have to spend time preparing change orders and claims, that's time lost. That's time where they could be doing, the personnel could be doing something more productive towards the finish of the contract or some other contract. So they have to think not only, so that even makes it more important that they understand the process up front, so they don't go through a learning curve that's going to affect them during the middle of the project. And as I noted, RP 100R19 goes through a lot of what I'm talking about. So now let's talk about the steps that it takes, this different, I call them different entitlements, or the elements necessary to demonstrate entitlement, overall entitlement of a change order or claim. John briefly talked about it a little bit. It's about, liability, causation, and damages. Those are the three main ones that you might hear people talk about. I broke it into a little bit more detail because some of these things, they need to be discussed as they are topics of dispute from the very beginning. And one, I'll start with the first one. Well, I'll just go through them real quick here. Some people might find this funny, but it's not always funny when it goes to court. The fact that an event that caused a dispute even occurred. That's the first one. Then, as John had talked about, and I agree with him 100%, is adherence to notice requirements. That's usually a biggie with contractors. They sometimes forget that they have to submit notice to the owner, and I'll explain why that's important. Entitlement to request a change. Does the contract even allow you to request a change or submit a claim for whatever the topic of dispute is? Causation, as John touched on, causation is a cause and effect. What caused the effect, which is usually some financial or schedule impact? Did the contractor prudently make an effort to mitigate whatever the issue was? That is another biggie that comes about where and I'll talk about that a little bit more also. Then assignment of responsibility. When you see, like we were just, John was talking about concurrent delays, a great example of that. You got to make sure that the responsibility is understood if both parties are responsible in part or whole, and how to demonstrate that. And then last but not least is the quantification of the impacts. What is it that the contractor needs to understand before they submit a piece of paper with some dollar amount or number of days required? So let's jump now to the first item, and that's causal event occurrence. In this case, the contractor has to demonstrate that the event actually occurred. Sometimes it's not so obvious. And as I note here some examples, there's always this argument. Was what the designer sent to me in a letter or a quick email, in fact, a scope change, or was a clarification, as he noted? There's a big difference, right? For the contractor, what the designer calls a clarification could be a scope change because it costs money or time to resolve it. And so, from the perspective of the designer, they might think it's just a teeny little, a minor change on on the paper, on the document, design document or a spec. And that could mean thousands or hundreds of thousands of dollars or days because of that minor change. And so that often is a cause of dispute. And then, rainstorms, in Brazil, everybody should expect it to rain at least, and I've worked on projects in like Las Vegas, Nevada, off the strip there. And the contractors, they'd say, well, if it rains any more than they would draw a circle, like about an 18-inch circle in the dirt. And when it started raining, the way they checked if it rained, if it was a rain day, was they counted like, I forget what it was, like 50 drops of rain in this circle in about a 10-minute period. And if they counted 50 drops, it was a rain day. And in their minds, that was enough to stop the work. And so you have to ask yourself, so it depends on, where you are, where the climatology is. And so that's another problem, is whether the alleged, there's a alleged event actually occurred. And also I worked on a project in Trinidad, the island of Trinidad. There's like at the very north end of the island, there's like one rain gauge. Well, the project that I was working on was on the south end, and the climate was different. And so can you really rely on the rain gauge on the north end of the island where the airport was and say that, that really rained 2 inches on that day when it might have been sunny and dry on the south end? So those are the other things that you run into sometimes. All right, next, adherence to contract notice requirements. I'll touch on it briefly. The owner, and I work for contractors and owners. I'm sure John does the same. But so that means I try to understand the position of both sides and their perspectives. And the owner, it's so important for the owner to have notice, because it allows them to, and I'll move on to the next. It provides the owner with a chance to investigate whatever the contractor is claiming is an issue that's caused this impact, and allows them the chance to avoid or mitigate whatever the circumstance is, so it doesn't add more cost and more schedule prolongation to the project. And for a contractor, it's a simple, write an email, something very quick and easy to send to the owner. Usually, I've never seen contracts ask for anything more formal than that. But also, if there's a lot of damage, as I say in my last point there, it allows the owner as quickly as possible to start looking at ways to make budget adjustments. When I worked for a contract, I worked for a school district here in the U.S., and they have to update their budget every month. And so when we're working on a school project, if a claim or something happened that would have cost the school district more money on the construction site, they wanted as much notice and warning as possible so they could update their budget for the following month. And so that's probably an extreme example, but that's what happens. And same with the U.S. federal government. They're trying to update their, was it every October 1st? It's a new annual budget. And if you're having in a project and you're having a dispute or let's say a change, let's just call it a change in a couple months before that, definitely the owner would want to know if it's going to be significant enough so they can make sure it gets into the next fiscal budget. Contractual entitlement to request a change. Again, this might seem funny, and why, you ask yourself, why would I even be worried about that? You'd be surprised on how in some contracts that I've seen. I worked on a big refinery issue in South America, and the contract, specified basically 4 areas the contractor could request a change. And it was very, in a way, it was a little onerous. But that's the way the contract was written. So the contractor has to demonstrate that, whatever it is they're asking fits within the context of the contract. And also the contractor needs to make sure that what they're asking for is out of scope. That's always a big question, and also a big debate sometimes with the owners. As I note in my last bullet there, the contractor must demonstrate the owner is not paying for the same work twice, because that's, the owner doesn't want to do that for sure. So causation, this is probably John and my favorite subject, because it is the most difficult aspect of a change order or a claim. Most difficult for a contractor, demonstrating causation of all the steps that I'm going to talk about, because it's can be very gray. And if a contractor does not do a very good job maintaining documentation, recording the events of the project, it will be very difficult for them to to show this cause and effect phenomenon between whatever the delay event or impact event was and how it translated into these added costs or delay. You can't just say, well, that it rained yesterday and therefore now you owe me $5 million. You've got to be able to show how you were damaged. You've got to show how that rain actually affected your work. Photos help, but even photos sometimes are not enough. You've got to be able to say, okay, well, it showed that this pipe was damaged, it was broken, or whatever it was. You got to be able to show how the water, it impacted your project, or whatever the event was. And I can't emphasize enough how demonstrating causation is the most difficult aspect for a contractor in a claim or a change order. And usually they're not. My experience is that contractors are good at what they do. And when it comes to understanding cause and effect, causation, usually they need support. And that's when they bring in people like John and me to help them with that, because we understand how difficult it is. And we also have our own little checklists of, okay, do you have this, and this, if you keep track of them, because we know that the other side is going to be asking for those very same things when it comes to demonstrating causation, or what they're evaluating the demonstration of causation, or we would be doing the same thing to the opposing party as well, because we know that it's it's just so difficult to show, and you got to be able to. And then a lot of times you got to demonstrate, if it's a trial, it's the worst, because you have to show this to 12 people who know nothing about construction and be able to demonstrate to them, this cause and effect relationship. So it can be really, the Achilles heel, the weakness of your case is right here in this. So we really got to, the way it can be best supported is with a contractor keeping good records during the project. So this is one that I see a lot with contractors who submit claims and do little to mitigate. And as an example, like a contractor is digging in the ground and he hits a water line that was not even on the drawings. So he clearly has a right to a change order, but he just lets the water spew like a big volcano, and goes to to the owner and says, hey, you see that big volcano of water coming out of the ground? I just hit that. And I'm just going to let that water run until you sign my change order. And usually it's not that quick. It's usually days. And in the meantime, this water is damaging the whole work site because of that. Well, the contractor has a duty to mitigate any damage to the work site or to the owner's property as a result of any other, of a change that occurs. And so that's one thing that I do, or we do as claims consultants, is we look to see if there is anything mitigating that the contractor could have done to reduce the overall cost to the owner. And as I note, that the owner may, dispute, and I've seen that happen, that the adjudicator, the arbitrator, the tribunal or the judge might say, well, we're going to give you your change order, Mr. Contractor, but you're going to pay back the owner for his cost to mitigate the effort. So mitigate the damages. And so that's, that's what happens a lot of times. Assignment of responsibility. John talked about that briefly, and that's, it's not always clearly cut. Sometimes there are intervening factors, as John had talked about, concurrent delay, other things going on simultaneously. Maybe this event A happened during last month that caused a delay, but there were 4 other things that were the responsibility of the contractor that also caused delays to the project. And so those all have to be weighed together. They can't be, they can be weighed, they can be evaluated separately, but they also need to be evaluated together when you've only got, let's say, a 1 month schedule updates, and everything happens during that month. So they have to be evaluated together. Lastly, quantification of impacts. Obviously, the contractor has to quantify his cost and time impacts, but he's got 3 demonstrations that have to occur for the contractor to demonstrate this entitlement, and that the costs and the days claimed were reasonable. So like we talked about earlier, is that, if the costs are ridiculous, like the home office overhead, the contractor's asking for a full year's worth of home office overhead, yet he's managing 20 other projects, that doesn't seem to be very reasonable. And the contractor has to show his calculations. So the additional cost and time were properly calculated. You have to show your time impact analysis, or whatever your delay analysis methodology was, and your cost, your product. If it's productivity loss, show us the detail on how you calculated your productivity loss, and provide all the documents that support that. And that goes into number 3. Adequate documentation is provided to support all schedule impacts and schedules. I got a job where I was working on a project at an airport where the contractor, I was working for the owner, the airport authority, and the contractor submitted a claim of, I don't know, it was a few $1 million. It was a small dispute. And I started going through all the backup documentation for his costs. And I noticed in there, he had decking lumber in there in his quantity of materials, wood. And this was, where do you build wood? Where's wood in an airport typically? And I started looking at that and what he had ordered, and he was trying to charge to the airport authority. He was building a new deck on the back of his house. And he even had the ticket in there where they delivered the wood to his house. And so, and I was testifying to this in it was a deposition actually. And I was pointing this out to the opposing attorney, showing him that, hey, your client was he bought wood that he, on the city's dime, paying the city, he wanted the city to pay for it. And the deposition closed right then and there, because the opposed, the contract's attorney just said, well, I think we're done now. So after I told him his client was trying to get the city to pay for his to help it build his house. So anyway, so that's why it really makes a difference that you really have to really review the documents that you're, and you have to prepare good backup, and it has to be supportable for your costs.
Sorry to interrupt. We have a question. I think might be appropriate to deal with it.
Sure.
Now. Not exactly what we're talking about in terms of what to do, but who, I guess. So the question is the project controller or the project manager the main agent in demonstrating the documental evidences and entitlement of a change order or a claim? I guess
usually so you're talking about okay, so for the contractor, yeah, I would say yes, because they're the people, for sure, the project controller that you would assume is keeping the records. They're keeping all the cost and schedule records, so they would know where they are at. Now, depending on the size of the dispute or the claim, some people might bring in a consultant to help them organize it, because it might help them identify the most relevant, the most important documents. And also, that reminds me, keep, for each change order, keep separate files for each one, because that makes it easy when it comes to a dispute. You've got your file right there that contains all your cost documents and your records and photos and everything else. But definitely when it comes to a dispute like an arbitration or a trial, the project manager and project controls people are probably going to be on the opposing side's list of cross-examinees. They're going to be testifying. They're going to be deposed, because the opposing side's going to want to know how the project was managed and how project controls was managed. So yes, they are very important people in this change order and claims management process.
Thank you.
Is that it?
Yeah, for now, yes.
Oh, okay. So I'm closing up here. So as John had mentioned, and I'm going at a much higher level, project documentation is the key. As my second bullet point says, the party that documents a change issue the best usually prevails. And I'm talking between the owner and the contractor, because the owners are going to be as involved with documenting what's going on as the contractor will, once the owner knows about it. Or they should be anyway, involved. And contemporaneous collect as much data as you can, because when it comes to the time of a trial or arbitration, it's sometimes several years after the project was over, and people's memories tend to leak and forget things. And that's why it's important to keep the documents while the project is going on. Now, I know the project controls people and the project management people are going to say, no, we don't have time to do that. But it's really important when you see that there's going to be a claim or a change order, do the best you can to maintain the records and identifying while they're being created. Keep emails, keep letters, all those things, because they help people like John and me 5 years from now be able to tell the story, be able to understand the story, explain the story, and be able to explain it to a judge or an arbitrator tribunal. Okay. And John, I apologize, jump in. Is there anything you want to add? So conclusion, I got a few couple slides on this. The change order request or claim should address each of those 7 elements, or at least you should think about them. And they're more clearly defined in the recommended practice than what you're seeing here. And as I just was saying, be as complete as you can with all the supporting documentation, and offer a complete, accurate, and truthful narrative about the encounter conditions, because I've also seen this as well, where sometimes contractors or owners are not completely truthful, and the documentation might dispute what they say, and that undermines this person's credibility, and that doesn't look good in front of an arbitration tribunal or a judge. So you have to be as truthful as you can, be reasonable, try to keep emotion out of whatever you're doing. I know this, the owner might have tried to cheat me out of dollars and I'm going to get back at him. We can't have that attitude. It's all tribunals and judges. They don't care what you think. Anybody thinks, any party. They don't care what any party thinks about any dispute. All they want are the facts. And they ask people like John and me to interpret those facts into a conclusion that based on our experience. Same with what we call the fact witnesses, which are the people who actually worked on the project. All they care about are the facts as you can remember them. No one's going to ask you your opinions. So don't offer them. And admit and take into account problems that are the contractor's own responsibility. So if you're the contractor submitting a claim, own up to any problems that you have as well. You may not do it with the first change order, but when it comes to a claim or dispute and people start getting involved, like attorneys and John and me, we're going to find it typically. And you don't want to be embarrassed. You want to be able to say, yeah, we had nothing to do with this, or yes, at the same time, the owner was delaying the project. Yes, we were delaying the project, but not as much or equally so, something like that. And then we have to show that. And then again, reflect that the pricing is reasonable and well supported. Lastly, as I noted before, everybody in the project team needs to read the contract, especially the people who are involved with the change and claims management sections. And, if you get, and John even touched on it, and I'll keep touching on it, you don't have to have your lawyer in your construction trailer, but he needs to know what you're doing. And if you run into a potential claim or change, please talk to your attorney and make sure that they understand what's going on, because they do understand. Well, good construction attorneys know what they're doing and know how to give you good advice. And with that, I am done.
Awesome. Thank you. Thank you, Steve, very much. It was also very good, very detailed and very useful for those who could be with us today. I do have one question, or it's more a comment perhaps myself. And you did touch base on that at the very end. And I think that, would be interesting to quickly talk about the role that expectation management plays in this environment. Because it's often the case that the contractors are, they have a chain of command, and the project manager perhaps is reporting to a director and to a VP, and they already said to the headquarters that they have this amount of claim, but they know they don't, they're trying. And on the other way around, sometimes the owners are also kind of doing the same, and they're all not always being truthful, as you well said in the end, to the facts and what happened and what they really agreed on the contract. So perhaps I'd like to listen a little bit more about that, right? So how important it is that expectations are well managed to make sure those processes are effective and efficient, and people are not, putting time on things that is a gamble, essentially.
John, do you want to take that, or do you want me to?
No. Sorry, I missed it.
Okay, well, I'll take it. I think, Philippe, it has to do with corporate culture. I've worked with contractors where the owner and all the way up to the top wants to know day to day, got to report day to day on what's going on with a project. And I've worked on contracts where, the superintendent, it's like, don't tell me. I had a guy like a vice president who all the superintendents reported to, and his attitude was, and I remember his words so clearly because it's when I worked for should I say Bechtel. So his words were, don't tell me about the storms on the high seas. Just tell me when the ship comes in. So his attitude was, I don't care. You deal with the claims and you deal with, he's telling the superintendents that. And I thought that wasn't quite right, but that's what he told his superintendents. And so it has to do with corporate culture on how the chain of command is involved with claims. Now, when you start getting people like, attorneys involved, yeah, it definitely is going to go really high. It's going to be, the CFO is going to start getting involved possibly, and the president, all the C's are going to be involved if it's a significant enough project, especially with a contractor, because usually it's a major thing for them, and owners maybe, but definitely with the contractors, you're going to get the top dogs involved if it gets into the arbitration litigation side.
Yeah, great, good stuff. Very good stuff. I don't know, John, or perhaps Steve, either or both, want to have some final comments. We still have another few minutes. Yeah, just like final remark before I thank you formally for the efforts and for your time.
The one thing Steve was talking about earlier struck me was that about, for example, giving notice and whether it's notice or not, the owners have, don't assume that the owners don't need the documentation and a change order to be properly documented just for them to make a decision, because they may be passing those costs on somewhere else. Whether it's to get funding from the public or from the federal government or the bank, but they may have other reasons for needing a package put together, and the better you submit it, the more cooperative they may be. Right. And try, I'm not going to say understand where they're going, but there might be, that's part of the communication is what's the process here? How are we going to get paid? What do you need from us for this change order? They could be hard about it and say nothing, we're not going to approve it, or they could say, it needs to be backed up sufficiently, and we may ask you to come with us somewhere. So don't assume that your documents are not going to be seen by somebody else as a project participant, right? Like a change order, it might go up to the FERC or some authorizing authority. So your documents, the work you do is very important, and so that's why when you're submitting changes, it might not just be yourself getting money back. You got to think about the client and what they're going to do with it.
Yeah, interesting. Good point. And sorry, but it did came another question here. So I don't know if Steve, you want to comment on what John said, but perhaps I just share the question and you'll see how it goes. But the question is, I found it interesting actually, the question, Guilherme Campos, thank you. So if the contract is not clear on how to treat change orders, can the parties agree on a procedure along the job? Have you seen it happening in your experience?
I've seen modifications to change order processes in the middle of the job. I've never seen like they shook hands in the middle of the project and said, let's do it this way. I've seen that probably something similar to that towards the end, where they couldn't resolve any of their changes. And so they resolved to take an easier route, or, agree to disagree kind of a thing. But I don't see why, if the contract doesn't have a very good process written and why can't you make a process in the middle, make sure it's in writing, and make sure both sides countersign? And why not? And maybe have your lawyers look at it, of course, but I think if both sides agree to the process at some point in the project, that would be acceptable.
Yeah, I was going to say, I mean, if you are in a situation like that and you realize that's what's happening, just try to act on it as soon as possible. Because at the moment you start having issues, then it's already too late. I mean, it starts getting more and more difficult for you to agree on anything.
Yeah, right. I agree. I mean, you might get into a dispute on the first change order, but if you can resolve the process before the second change order, that's going to save you a lot of headache down the road.
Yeah. What's the legal term? I can't think of it for some reason. Like it becomes the modus operandi on a job. Like okay, the contract says this, but this is what happened, and we did it for 4 change orders, kind of shortcut to keep the job going. And like we agreed to do the work before it was signed, and then that turns out you did it 3 or 4 times, and then suddenly you say, well, we're not going to do it. In the long run, when it gets to the end of the job and there's a claim, somebody's going to say, well, you did it here, here, and here, and then suddenly, why did you suddenly decide not to? Right. And then you start talking about breach of contract, and
and that's why I said, put something in writing, that both sides with authority, a person with authority can sign, and you can make those changes, and make sure you have your attorneys review it and make sure there's no loopholes or problems with that. One thing I'd add is that I've seen many projects where the change order requirements say you shall not proceed on the work until the change order is signed, or even the change request is signed. And I've seen equally as many contracts where the contractor did it anyway, or the owner directed him to do it anyway. So that's another one where I hate that language where they say you can't proceed until the change order is signed off. Well, it could be a month before it's signed off.
It could be a year.
Yeah, but
I have a case in New York where it was a city job, a water treatment authority, and just months of the process, right? And then they ask for a revision to it, and it just puts it back in the cycle. And the contractor's 95% done now, and he's like, all right, I have all these overhead costs. What am I going to do? I can't do this work. So
is the owner going to tell him he's in breach? He did the work.
It's funny language, right? Because it says don't do anything. Then at the same time, probably the same contract says contractor has to be prudent and cannot allow for the damage to continue getting worse. So,
exactly.
Okay. Well, awesome. We have 2 minutes, so I'll take the time to thank you guys very much for being part of this. I really appreciate it. The ACE Brazil section appreciates the efforts and the opportunity to learn from you guys, to listen from you, and to for you to be here tonight, sharing your experience and knowledge with the Brazil ACE section members and others interested in the profession. I saw people from different countries participating here. So we saw people from Ghana, from Bolivia, from Mexico, France, US, and Brazil, obviously.
How many people? Do you have a count of how many people?
We had at some point about 20, if I understand well, the YouTube counting here. Right now we have 12. I know it's late in places where
well, I would also offer Philippe, I mean, if anybody has any further questions, feel free to forward them my contact information. I'm sure John, I don't know if you're up for that, if you want.
Sure.
But I'm okay with that if they have any questions.
Excellent. Will we be able to share the presentation?
At least for mine, I would just say look at the RP, because the RP has much more detail than this presentation does.
And I would say go back to the article, because it's really based on that. And Steve, I don't know if you're presenting at the annual meeting in Chicago.
Oh,
if you're presenting this, or if you're presenting the cumulative impact one, but I'll be presenting this at the annual meeting. So you guys got a
I
preview
don't
of
know
a,
yet.
rough draft.
I'm co-authoring 2 other papers, and I haven't even thought about this one. Actually, I gave this one at the San Antonio meeting, the one we just watched.
Okay.
The version of it. Cumulative impact, I might give that one in Chicago if they give me some time.
Well, if you've got 2 papers already, maybe save it
Yeah.
for 2024.
Yeah, possibly.
Fair enough.
By the time you get your
Right.
comments done, right?
Yeah, exactly. I'm going through them now, but yes, slowly but surely. Got all yours. I got yours already worked in, buddy.
Oh, great. Thanks.
Okay,
All right,
anything else, Philippe?
No, with that, we'll finish it for today. Thank you very much. Hopefully, I'll see you guys sooner than Chicago. So, yeah, looking forward to the next opportunity. Thank you very much, guys. And thank you very
Okay.
everybody who participated.
Thank you.
Have a good
Thanks.
night.